Right, on this, what are we here for?
This
Motion
is-
to revoke?
This is a restitution, to add restitution to the case.
State, are you ready to proceed on the restitution hearing?
I don't know, Your Honor, because Mr. Basile has.
I have a legal
an
issue.
interesting Argument.
Yes.
All right, Your Honor, my argument is that the court took up this case on May 7th, 2024, granted a deferred adjudication. At that time, the order states there's zero restitution on the court's order, the written order. And also in the conditions of probation, it doesn't have any amount. It has to be determined, doesn't have any amount on there. This notice requesting it that I'm seeing in the printout was filed on June 12th. It's my argument that that order that was issued by the court on March 7th became final. 30 days later, that was a final order. And since under case law I've researched and found, and I can give you the sites, the courts consider restitution to be part of the sentencing. And it's my order that to proceed on would be a violation of his due process, considering that as a final order by this court. And the court cannot change that. There are also the court cases I've read from the Court of Criminal Appeals says the court cannot go back and order restitution if there wasn't restitution originally ordered or a restitution hearing that was set up to determine later.
All right, so a restitution hearing was set up on June 25th, 2024.
And I didn't see that on the printout I got from Odyssey.
Okay. Odyssey is
Well, there's
incorrect.
June 25th, that's correct.
Yeah,
But
June
but the
25th.
supplemental report submitting, asking for it was filed on June 12th. So there was not a request, there was a request on June 12th to set it, which is more than 30 days after this court sentencing. That sentencing order became final after 30 days.
All right, so then honestly, what the issue is that the judgment that was issued is not a correct judgment. And let me explain to you why it's not a correct judgment. When I accepted the plea bargain agreement, I sentenced him to $2,000 fine probated, 200 hours of community service restitution. He was either obtained his GED or a certificate from a trade school, and the community service hours were deemed satisfied. Took into consideration County Court 12 cause number. And then I ordered that there was restitution to Kenyana Warner in 708710. And that was ordered on the record. So the problem is the judgment is incorrect. And there needs to be a correction of the judgment. I mean, we can't stay with an incorrect judgment.
It would still be an argument that that judgment is final, and I bet I can give you the case law.
No, I understand what your case law is, and I understand what you're saying. So everybody step back. All right, thank you.
Exactly which ones. Some of them were on case in the cases I was
All
told
right,
the
if you
court
want,
have sites for, so.
all right, if you want a chance to read that, you can, but from what I reviewed, it appears that I can give restitution in this case.
That's fine. I mean, I'll take exception to your ruling, Your Honor. I think.
Well, no, I mean, do you have some case law
Well,
that,
I have
that addresses 42.037?
I have case law that, yeah, I can get you the sites. I have them here on my
Okay.
computer.
All right, sure.
Yeah, I can write them down and give you the sites.
Okay, awesome.
Yeah.
All
Okay.
right, just step back.
Eviction is final or the other deferred is different. I understand kind of the law.
So if you would like, I can make my ruling now for both parties. And from what I've read, I still have jurisdiction to order restitution. I don't know if y'all have agreed on a restitution amount, but what I can tell you all is that I'm not going to order her to go through her insurance if she
And-
doesn't want to go through her
And I
insurance.
agree with that, Your Honor. I researched that issue. That was an issue last time. I could not find any case law that says she has to do that.
All right.
The only case law I could find, if she did, then that's credit against his. I didn't find it required. I explained that to my client. So
So-
that is correct.
So then the question is, have you all agreed on an amount of restitution?
No, Your Honor.
I don't know.
All right, if you all want to confer and see if you all can come up to an agreement on the amount of restitution, like I said, based upon my review of the case law, and I re-reviewed.
Yeah.
And based upon the article I gave you, I'm of the opinion that I do have the right to still order restitution. So we're just now at an amount what it should be. And I don't think anybody has to use their insurance if they want to be. So the restitution is not just her deductible. So
And I agree with on the insurance part, Your Honor. I'm not objecting that anymore. I researched that issue. On the other one, I'd just like to make on the record, so in case my client wants to do something, he'll have a record.
okay, so then let's do this. Let's see if y'all can come up with an agreement on restitution amount, and then I'll allow you to put whatever arguments you want to put on the record so you can make your argument. All right, thank you. All right, we're back on the record in 2024 CR 1043 State versus J. Juarez. And if you all could re-announce for the record, please.
Carl Basil for the defendant, Your Honor.
All right. And Mr. Basil, the court had considered your argument. The court reviewed Article 42.037 with regards to restitution, and based upon that article of the courts, it's in the court's opinion that the court can still order restitution in this case. And I'll let you place on the record whatever you would like to place on the record as it relates to that. And
Yes,
then
Your Honor.
we'll speak towards the restitution.
It's the defendant's position, Your Honor, that since this court granted the deferred adjudication on March 7th, 2024, and at that time in the court's judgment, there was restitution was listed as 0. And on the conditions of probation, there was no amount of restitution listed. That by rule of law, that order became final after 30 days and became a final order. Just like if the defendant wanted to appeal, he didn't want deferred adjudication, he would have to have filed that within 30 days. On June 12th, the supplemental request was submitted set the case for restitution hearing, which is more than 30 days after that, and is the defense argument, Your Honor, that the court at that time does not have the authority to go back and change the judgment. And I've submitted some cases. I wrote them down. My computer's battery's about dead here, so I'll have to read them off the paperwork Your Honor gave you.
Yes, no problem.
Cases that I researched, and while there's not directly, so court knows they're not directly on issue because they're mostly talking about probation. And I understand the statute that you're talking about mentions probation. Most of the time, there is some places in there it does talk about deferred adjudication on there. It's Cox v. State, 445 Southwest 2nd, 200. It's the Texas Criminal Court of Appeals, 1969. Bailey v. State, 160 Southwest 3rd, 11. It's also Texas Court of Criminal Appeals, 2004. Ex parte Cavazos, 2003 Southwest 2nd, 3rd, 333. Texas Criminal Appeals, 2006. And ex parte Roberts, which is 409 Southwest 2nd, Southwest 3rd, 758. Texas Appeal, San Antonio, 2013.
All right. Thank you.
Those are the cases that were provided on the notes to the court that I'm relying on, other than just the general, also under under notice provisions under due process clause, United States Constitution, the 5th and the 14th Amendment, and the Texas Constitution, Article 1, Section 19, which requires that he be given due process before any life, liberty, or property is taken from him. And it's our argument that since that order was final, the court does not have the jurisdiction to do that.
All right. And the court will note for the record that on March 7th, 2024, as a part of the plea bargain agreement, the court ordered that restitution was to be determined to Kenyana, Keyyana Warner. And according to the plea bargain agreement, stated that restitution was to be payable to Keyyana Warner, the victim in cause number 708710. That was a part of the plea bargain agreement that was agreed to by Mr. Juarez on that day, and that is a part of the contract that he signed. With regards to the judgment stating that no restitution, it states $0 restitution. The court is finding that was in error. It should have been that restitution was to be determined. And this case has been reset more than once for both parties to come together to see if there is an agreement on restitution. The first restitution hearing was scheduled for June 25th, 2024. Then it's reset for July 18th, 2024 for the state to obtain proof that the complainant did not use insurance. And that was at the request of the defense because the complainant had a deductible. Then it was recalled for August 1st, but defense attorney was ill. And then it was recalled on August 1st because the defendant was ill on July 18th. And then on August 1st, we were to have a restitution hearing and a witness was allowed to appear by Zoom. And now we're here on September 12th. So have you all come, the court has received documentation of a preliminary estimate for restitution. And they put that total at $6,399.22.
That's correct, Your Honor. I've received that. I've reviewed that with my client, and my client is desiring to have a hearing and evidence presented on that amount. I've discussed that with him in detail last time and further detail today in the courtroom.
All right, state, you'll need to have witnesses here then for this being the amount of restitution.
When you're on.
How long will it take you?
I will need to ask Ms. Warner, so I don't know right now.
All right, so what we're going to do, and this is going to be the last setting that I'm giving everybody for restitution.
Just so the court knows, Your Honor, I will be out starting tomorrow through next Wednesday. I'm having a medical procedure
No.
done tomorrow, and I will be back. So I'm just.
All right, do you want to do it, is October 21st good for you or no?
No, that's fine. I mean, I'll be back before then. I just want to let the court know if you want to do it next week, I'll be out.
Okay, no problem.
And Your Honor, I should be able to secure it.
All right, Norma, this case is going to be recalled October 21st, and this will be the last setting for restitution.
Your Honor,
Yes.
will Ms. Warner be allowed to testify via Zoom? There is no objection from defense counsel.
I have no objection to that.
All right, she'll be allowed to testify by Zoom.
But, Your Honor,
All right, thank you.
If you are new to my channel, please subscribe as I edit these cases and remove all of the mundane, boring, repetitive stuff. And I even remove the silences, so you get only the juicy bits, which I think are always the best bits. Are looking for another episode that has all the boring stuff cut out and gives you just the good stuff, then here a couple that may interest you. Enjoy.